All right, welcome everyone to the Judiciary Committee hearing, the St. Patrick's Day version. We have two agendas today, one at 9:45. This is a governor's message. This is for Governor's Message 506, Lonnie Ewart, for the Commission to promote uniform legislation for a term to expire on June 30th, 2029. And then at 9:55, we have a bill agenda as well. If a 2-minute time limit on testimony, either on Zoom or in person, and if we have a major crash, we'll try again on Friday, March 20 at 9:45. And for those who are on Zoom, for those testifying on Zoom, you won't be able to, the audio will be muted and your picture won't be available until it's your turn to testify. Okay, on the first agenda, the 9:45 agenda, as I mentioned, this is for Lonnie Ewart for the CPUL. First up on the testifier list on this one is Jill Nagamini, Deputy Attorney General. In support, Elizabeth Kent, maybe on Zoom.
Present, Chair.
Good morning.
Good morning. Lonnie's very humble and not one to sing her own praises, so it's my pleasure to do that. Lonnie, I know you're going to blush and this is going to be uncomfortable, but it's going to last less than 2 minutes. In my written testimony, I mentioned Lonnie's dedication to the Uniform Law Commission's work in producing well thought out bipartisan products on issues of importance to the states that call for uniformity between the states and that will be enactable. She believes that this helps the people of Hawaii in their daily lives. And so for 49 years, Lonnie has served faithfully as a volunteer uniform law commissioner. If my math is right, she's been nominated by 7 different governors, and this is her 12th confirmation hearing. And I can't even begin to count how many drafts she's worked on and brought to you for enactment. That's commitment. Lonnie has attended each of the 49 annual meetings since she was appointed. They last about a week each and are full of days of sitting in big conference rooms with commissioners from other states, going over proposed bills line by line. Her thoughts and suggestions are respected by other commissioners, and she's participated on other committees and been part of leadership. That's commitment. Sometimes the state has not had the funds to cover the commissioner's expenses, and I estimate that she's covered some or all of the costs for herself for between 15 to 20 meetings. And she was accompanied to those meetings by her wonderful husband, Yusin, so that added to the cost. That's dedication. Being a good commissioner is more than just attending annual meetings. And I believe that she spent approximately 150 hours a year working to produce those. That's over 5,000 hours. You may not know that one of the first women to serve in the ULC was from Hawaii. That's Marguerite Ashford, and she was a trailblazer starting just after the 19th Amendment was ratified. Well, Lonnie was the very first woman to become a life member, and she too is a trailblazer. And for these reasons and more, I urge you to vote yes. Thank you very much.
Thank you very much. Next is Peter Hamasaki, in support. Michael Tanoe, also in support. Bob Toyofuku, in support. That's everybody that I had that signed up on GM 506. Would anyone else like to testify on GM 506? Seeing none, members, any questions for Ms. Kent? Seeing none, Ms. Ewart, come on up. If you'd like to make an opening statement of a couple minutes, that would be great.
Thank you for the opportunity to answer any other questions.
Before you
might
go on,
have.
maybe you should pull the mic a little closer. It'll move.
Okay.
Yeah.
Is that better?
That's
okay. Thank you for the opportunity to answer any other questions you might have about my nomination to another term or the Commission to Promote Uniform Legislation. As Elizabeth Kent indicated, it's been a long time, and I've done this for a long time, and it is something that I've enjoyed and I'm grateful for. And I also think that I've given in a way that I'm able to the laws of this state as well as the other states in the nation.
Okay. Were you finished? Was that?
I am
I
finished.
didn't mean to cut you off.
That's about it.
Finished. Members, any questions? Well, Ms. Kent said 49 years. So you've been serving on the commission since 1977. Is that correct?
That's correct.
Obviously you find it rewarding somehow. What are the high points for you of being a commissioner?
I think the high points are seeing a process where there are a number of different views that are raised about laws that might help citizens of all the states, and working with those viewpoints, not only by commissioners from each of the states, but also with observers and people who are interested in those laws, and coming up with compromises sometimes, and going through debates and working through the different questions that come up, as well as the different terms of the law. It gives us time that sometimes I know a lot of legislatures don't have the time to devote to laws.
Are there particular model codes that you anticipate, or maybe let me back up. Are there particular topics that you expect to come up in this coming term of yours that you're particularly interested in?
In this coming term, there are some topics that deal with healthcare, as well as the discovery rules. There are some of the acts deal with laws that might in some states be enacted by, or not enacted, but adopted by the judiciary. So there are some of those that are up for adoption, or at least for debate.
Okay, other questions? Senator Vice Chair Gabbard.
Well, you've given us the high points. How about the low points? You gotta have the other side.
Well, one of the low points is definitely, and unfortunately, the inability to have financing for our required trips. Everybody serves, all of the commissioners for the entire national group serve without pay, and every state decides how much they will support the commissioners. And so Hawaii has been generous in the past in paying our hotel and travel, and sometimes a per diem, picking up our registration fees. But lately, it's been very difficult because of the budget to fit us in. We fall under the Attorney General's budget, and they try to give us as much as they can. So that is a low point. And the other low point sometimes is not having, not being able to enjoy the places that we are at, because we are in sessions from usually 8 or 8:30 in the morning till 5. And it runs from Friday, Saturday, half a day Sunday, and then Monday, Tuesday, and Wednesday. So sometimes that's very difficult. But we have a very good group of commissioners, and we figured out a way that we can each take a particular act to focus on, and give the others a chance to take a break during the session, during the annual meetings.
Thank you.
Thank you.
Other questions? If not, I'm prepared to vote. If everybody else is, let's go ahead and vote. I just have to get the wording right here. The recommendation is to advise and consent to the nomination of Lonnie Ewart. Questions or concerns? If not, Vice Chair.
On Governor's Message 506, Chair's recommendation is to advise and consent. Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Chang.
Aye.
Senator San Buenaventura.
Aye.
Senator Awa.
Aye.
And the measure is adopted.
All right, congratulations. We will adjourn this. We'll adjourn this agenda. Okay, coming back in for the 9:55 agenda. This is a House Bills agenda. As I mentioned before, if we have a if we have technical difficulties, we'll try again on Friday, March 20 at 9:45 in this room 016. 2-minute time limit, and if you're on Zoom, your audio and video will be not available until it's your turn to testify. All right, first up on this agenda is House Bill 1247. This allows a party aggrieved by the judgment of a circuit court on a minimum term order to appeal to the Intermediate Court of Appeals. Requires prisoners to continue to be represented by counsel in any petition challenging minimum term proceedings. First up on HB 1247 is Haley Chang for the Public Defender. Good morning.
And good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. My name is Haley Chang. I'm the first deputy of the Office of the Public Defenders. We have submitted testimony in support of this measure with some comments. I do want to first clearly state that we are always going to be supportive of measures that give the opportunity to people to have review, whether it's through the judiciary, the appellate courts, or by the parole board itself, to look back and have the opportunity to challenge things that may have gone wrong. We support the spirit and the intent of the measure. We also wanted to clarify that we believe the right to continued counsel should exist for inmates, even those who did not initially have representation at their initial minimum hearing, and we included some reasons why in our written testimony. Some may forego that right at the hearing, but we believe that right should exist through any later challenges. We do want to say one thing. Our office currently does not have the capacity, if this measure were to pass, to take this on. I think other testimony has indicated that there were over 1,000 minimum terms in one calendar year. Majority of those, I can assuredly say, were handled by our office. So we do not, in our current capacity, have the ability to take this on, and as we believe, and rightfully so, that many of these individuals would challenge their minimum hearings. So we do just want to highlight that and flag that, and we've included as a part of our testimony what we believe we would need meaningfully to take on this role. Otherwise, these individuals would have to be assigned court-appointed counsel if we cannot take on the load. So thank you for the opportunity to comment, and I will remain available for questions.
Great, thank you. Next up is Jeanette Castanetti for the Judiciary with comments. Next is Office of Hawaiian Affairs in support, and Veronica Moore in support. That's everybody who's signed up on HB 1247. Would anyone else like to testify in this measure? If not, members, any questions for Ms. Chang? I don't either. Let's go ahead and move on to the next bill. This is HB 1516, requires certain factors to be considered when determining a defendant's financial ability to afford bail. First up on 1516 is Office of Hawaiian Affairs in support. Next is Kristen Johnson for the Hawaii Correctional System Oversight Commission. In support, next is Haley Chang for Public Defender. Morning again.
Good morning again. Our office stands in strong support of this measure, and we just note that the bail statute itself, chapter or section 804-9, states that a bail amount should be so determined as not to suffer the wealthy to escape by the payment of a pecuniary penalty, and nor to render the privilege useless to the poor. And again, the Office of the Public Defender, who represents the indigent defendants throughout our state, sees this happen time and time again, that this privilege of bail has become rendered useless to the poor. We believe this measure and the factors that the courts will be required to consider, or the agency setting bail, are needed in order to ensure to the best of its ability that that does not continue to happen. So we stand in strong support, and I will be available for questions.
Thank you.
Thank you.
Next up is Christine Denton for the Department of the Prosecuting Attorney for the City and County in opposition. Next is Keldon Walton for the prosecutor for the County of Hawaii on Zoom, maybe.
Not present, Chair.
Also in opposition. Next is Darnella Villanueva for the Hawaii Police Department in opposition. Melissa Pavlicek for State of Hawaii Organization of Police Officers in opposition. Kat Brady, Community Alliance on Prisons. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. Thank you so much for hearing this measure. We have so many people in our community who are struggling to put food on the table, if they have a table. who were houseless. So this is really important. I included some data from the Alice report, which is, the asset limited, income constrained, and employed. And these numbers are from 2024. And people are leaving Hawaii because they just can't afford to live here. And, to me, many of them are Native Hawaiians, and that is so heartbreaking that they have to leave their homeland because they can't even afford to live here. The number of Alice households in Maui County increased by 9% because of the wildfires. And, I think we need to take that into account when we look at people. So thank you. I know too many stories of people who couldn't even make $10 bail. So thank you so much for hearing.
Thank you. Next up is Chris Caulfield for Inua Alliance in support. Next is Mandy Fernandez for the ACLU of Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Mandy Fernandez on behalf of the ACLU of Hawaii, strong support of this measure. You have our written testimony. The evidence is very clearly on our side about why reviewing a defendant's ability to pay and releasing guys who don't need to be locked up in jail makes a lot of sense for public safety, to alleviate human suffering. But what I want to talk to you about today is that a few months ago, our entire team toured OCCC, and what we saw was haunting. Not just the conditions of the building, which looks like it's being held together by, asbestos and prayer, but also that people were being locked in cages and not being allowed to go outside and get rec time for more than a week when we were there. Can you imagine that, being locked up in a cage with several other cellmates and not being allowed to go outside for more than a week? And that was because COs are not showing up to work. I don't blame them. I would not want to work there either. The only solution that DCR has been putting out there is this new jail. And we oppose this plan for a couple different reasons. I'll name two. One of those is that it's not right-sized. It's not considering the decarceration effects of pending proposals such as this that could reduce the population, get people out who don't need to be locked up, who are not posing any sort of public safety threat if they're released, and are only being held there because they cannot afford bond. But second, it wouldn't be built until years in the future. That's not going to do anything for the people who are locked up there now. We know that the jail on the Big Island is even worse. We really hope that this committee will consider moving this measure and other measures like it forward, because we can't move forward with a $1 billion jail that the taxpayers are going to fund when it's not even considering how many beds there need to be, when it's not even considering the very real human suffering that's happening now and is being used as a way to avoid those conversations. Thank you so much.
Thank you very much. Next up is Ethan Chang in support, Isabella McRae in support, Greg Pupioni in support, Corey Harden in support, Gay Chan in support, Veronica Moore in support, Carla Allison in support, and Nandita Sharma in support, Nathan Leo Browlick in support, William L. Wong, CPA, PFS in opposition, Christine Andrews in support, Tony Lorky in support, and Jesse Hutchison in support. That's everybody who signed up on HB 1516. Does anyone else want to testify in this measure? If not, members' questions? I do have a question for public defender. I think at least when we've dealt with bills like this in the past, it seemed to me like there was a lot of misunderstanding about how the system works. So if someone cannot bail out, they can stay there for quite a while. I mean, indefinitely until their court hearing, until their trial comes up, if they don't plead out before then, right?
Correct.
Okay, so if they do bail out, then they're supposed to show up at court for their whatever hearings or trial they have.
Yes.
I guess the question is, for a lot of people, is do they? So that's the first question. Do they show up for court when they're out on if they've bailed out? Or maybe more accurately, does paying bail guarantee that they're going to show up?
I don't think there's ever a guarantee. We have people who are released on their own recognizance or who are able to post bail that unfortunately do not show up to court. What I will say anecdotally, though, is I think that's less common than people think. Especially with the bigger cases, if you are able to post bail, there are a lot of safeguards that can be put in place. The courts always have the discretion to impose conditions of bail. Conditions can range from supervision by the intake service center. Conditions can range from, check-ins with whoever the court deems fit, restrictions on travel, requirements to keep in touch with counsel, etc. So I think it's less common than people think.
Okay, so really, I guess the only way to be sure that people show up for their court dates is to not let anybody out on bail. Is that fair?
To guarantee 100% attendance at court, yes, that would be correct.
Is that in terms of the capacity of the prison or the jail, is that even vaguely realistic?
Absolutely not.
Okay.
Yeah.
One last question on the tail end of it. So if you don't bail out and then you go to trial and you're convicted, typically they'll give you credit for the time served, correct?
Correct.
So if you're in jail for a month and you commit a petty misdemeanor and they max you out and give you 30 days, you already served your term and they let you walk out the door at that point.
That is correct.
What if it's the other way around, then you actually have to be convicted of something first before you serve your jail term?
If you are released prior, correct.
Okay. Okay, thank you. Members, other questions? If not, we'll go ahead and move on to the next bill. Thank you. Next up is HB 1565. Excuse me. This establishes a working group within the judiciary to improve family court processes, including access to legal representation for youth in the child welfare system. First up on 1565 is Scott Boone for the judiciary. Good morning.
Board Chair, Vice Chair, committee members. My name is Scott Boone. I'm a staff attorney for the First Circuit Family Court. I'm testifying on behalf of the judiciary for this bill. We stand on our written testimony and I'll be available for any questions.
Great, thank you. Next up is Office of Wellness and Resilience. Says in person, in support. Next is Malia Tomdinik for Department of Human Services on Zoom.
Not present, Chair.
There's another staff. Somebody else for DHS.
Good morning. Can you hear me?
I can hear you. Can't see you, but I can hear you. Okay, now I can see you. Go ahead.
Good morning, Chair, Vice Chair, and members of the committee. Stacy Pasquale, Child Welfare Services Program Development Administrator on behalf of Child Welfare Services, Department of Human Services, Child Welfare Services Branch, and the department stands on its testimony and available for questions.
Thank you very much. In support.
Yeah.
I'm sorry, that's a question. In support?
Correct, and we defer to
Okay.
the judiciary. Thank you.
Thank you. Next is Office of Hawaiian Affairs. Also in support. Okay, Natalice Washington for National Association of Council for Children. In support. Next is Nicole Wu for Children Actions Network Speaks on Zoom. Good morning.
Aloha, Chair Rhodes, Vice Chair Gabbard, members of the committee. I'm with Hawaii Children's Action Network Speaks. We coordinate a group called the Children's Policy Agenda. It's been over 10 years of that now. It's several dozen, about 60 groups and people who care about Keiki in our state. We go through our own process, sort of like legislative caucuses, to pick a package of bills. This idea of making sure our youth have legal representation in the child welfare system was brought to us a few years ago, and we've put it into our package every year. We're really concerned to learn that we're in the minority of states that don't give youth this legal representation. So we definitely support the creation of this working group to move us closer to that. Thank you for hearing my testimony.
Thank you very much. Next is Sonia Blackistone for Hawaii Youth Services Network. In support. Okay, then there's a bunch of people testifying for Opportunity for Youth Action Hawaii, all in support. I'll run through their names quickly. If you're here or on Zoom, please let me know and you can testify. Melissa Pavlicek, Blakely Estacio, Kanyo Loy O Unia Mai Ka Aina Loa Aina Torquato, Anastasia Newman, Destiny Jade Roberts Wada, Serenity Soto, Aponi Boyer, Kiera Archangel, Precious Ahulao Kaleo, Sulinta Hemios, and James Lee. Continuing with that same group, Caprice Cool, all these are in support. Elena Barr in support. Keisha Rai, Pacheco Paglinawan in support, and Patricia Chin may be on. Yes, good morning. Go ahead.
Good morning, Chair Rhodes, Vice Chair Gabbards, and members of the committee. I'm Patricia Chin. I serve as the High Hopes Initiative Manager at Epic Ohana. Our statewide initiative does work with young people between the ages of 14 to 26 who have experienced foster care, ensuring that they have the necessary relationships, resources, and opportunities that they need to thrive. I'm here in strong support of House Bill 1565 because legal representation does change outcomes. In addition to supporting the bill, we respectfully request an amendment of an former GAL to be included in the working group member composition. A former GAL can offer critical insight into how representation currently functions, where the gaps currently exist, and how the system can evolve to better support youth rights and youth voice. In states that have already provided counsel for youth, young people are 40% more likely to exit the foster care system within 6 months, 45% more likely to reunify with their family, and fewer of them experience fewer placement and school moves. These numbers represent something deeper. They truly represent stability, healing, and hope. The most powerful evidence comes from our young people themselves, many of who wanted to testify today but are unable to due to work and family responsibilities. And I'd like to uplift their voices in this space. One of our youth shared that they often felt lost and did not feel as if they were represented. Another shared that if they had a lawyer, they could have avoided 4 grueling years in a placement that wasn't right for them. And then finally, a 17-year-old who is currently in the system has shared that important decisions were made about their future without their full understanding or their involvement. House Bill 1565 is a meaningful step forward to ensure that no young person is left in the dark or has to rely on chance to be heard. Hawaii truly has the opportunity to lead the way in honoring youth voice, protecting their rights, and building a system where they truly feel seen. High Hopes Initiative stands firmly in support of this bill with the amendment to include a former GAL. Mahalo for your time and for your commitment to Hawaii's young people.
Thank you very much. Next is Johnny May Perry in support, Judith Clark in support, Teresa Brano in support, Starla Ann Holding in support, Melissa Mayo in support, Keola Pagud in support. That's everyone who signed up on 1565. Would anyone else like to testify on HB 1565? Seeing none, members, questions? Okay, we'll move on to the next bill. HB 1716, this establishes a process by which any political party continuously listed on the general election ballot for 8 or more years shall be deemed continuously qualified for ballot placement. First up on 1716 is Jungmin Charles Lee, Deputy Attorney General.
Morning, Chair, Vice Chair, Committee, Charles Lee, Deputy Attorney General, submitted for committee's consideration. I'll be available for any questions.
Okay, thank you. Next is Shelby Pikachu, Billionaire for the Kingdom of the Hawaiian Islands and Ohana Unity Party. On Zoom, maybe?
Hello, chairs.
Good.
How you guys doing? Great job. We just have the other meeting with the chief elections officer. If you watch the Office of Elections meeting, there's a lot of corruption going on. So regarding this bill, it makes it very hard to establish any other independent parties because I was the chairman for the Ohana Unity Party, you have Aloha Aina, all these other ones. It's not fair to make these other people, the long establishment, go through this without doing any paperwork because it doesn't give the free chance and the free work because we live in America for other independents to foster other chance for groups. Like if we wanted a new party, you get all the college kids together, and if they just stuck it for 8 years, they could do that. So it doesn't really make sense to me, and it's not fair. So you should definitely say no to this bill, pass it on because it's not fair and it's not American. It should be unconstitutional. And it's a cheat system for those already established in the system. And some of those people have been in office longer than I've been alive. You guys know. So thank you very much. Appreciate you guys. Aloha. May the force be with you always.
Thank you very much. Next is Ann Frederick for Hawaii Alliance for Progressive Action. In support, Susan B. Roberts Emery for the Green Party. In support, David Mullenix for Our Revolution Hawaii on Zoom, maybe? Yep, good morning.
Good morning. Thank you so much. We totally support this bill. Dave Mullenix, Our Revolution Hawaii. The wording of the bill sums up our position, really. The purpose of this act is to promote fairness, equal treatment among political parties, reduce unnecessary administrative burdens for long-established political parties in the state, recognize sustainable voter support and organizational stability, and ensure consistent, predictable, and non-discriminatory ballot access. Anyway, it's a process that we need to expand our democracy. And this is ensuring that expansion of democracy and fairness to all. So thank you. Please vote yes for this bill and have a good day.
Thank you. Next up is Nanea Lowe, also on Zoom, maybe?
Not present, Chair.
In support, next is Christina Holt. In support, Greg Kahn. In support. List of individuals all in support. The total count is 19 in support, 0 opposed, 1 comment. And at this point, is there anybody else who would like to testify in HB 1716? Seeing none, members, questions? I do have a question for AG, if you don't mind. We're considering, we're a little concerned, well, partly because of your testimony, we're concerned about treating different parties differently. So what we were thinking is maybe we would just make it easier for all political parties to register. So, and I don't know if you have this in front of you, but HRS 11-62 subsection B, right now it's 3 general election cycles in a row and you're qualified for 10 years. I don't know if it's in the bill.
Oh, no. Sorry, I have that.
So what we were thinking is maybe make it just 2 cycles. So you'd have to qualify for 2 cycles in a row, and then you're qualified for 10 years. Just makes it easier for everybody, but doesn't actually change the qualifications and disqualifications. Do you see any problem with that? That's my real question.
Right now, as long as it applies to everyone, then it's fine.
Probably all right. Okay. All right. Thank you. Other questions, members? Thank you. If not, we'll go ahead and move on to the next bill, which is HB 1878. This prohibits discrimination based on the perception that a person possesses certain characteristics, the perception that a person is associated with a person who possesses or is perceived to possess certain characteristics, or the intersection or combination of 2 or more specified characteristics in relation to a person. Next, first up on HB 1878 is Keith Hayashi for the Hawaii State Department of Education, or his designee. Good morning.
Good morning, Chair Rhodes and Vice Chair Gabbard, and members of the committee. My name is Beth Schimmelfennig. I'm the Director for the Civil Rights Compliance Branch of the Office of Talent Management in the Department of Education. The department stands on its written testimony, which provides comments on this measure. Thank you for this opportunity.
Thank you. Next up is Sandy Harjo Livingston for the Hawaii State LGBTQ+ Commission. On Zoom, maybe?
Not present, Chair.
In support, next is Marcus Kawatachi for the Civil Rights Commission. Also on Zoom. Good morning.
Yes, good morning, Chair. Chair Rhodes, Vice Chair Gabbard, members of the committee. Marcus Kawatachi, Executive Director of the Hawaii Civil Rights Commission, and I'm appearing today on behalf of the commissioners of the Hawaii Civil Rights Commission. I stand on the testimony in support, and I'm here to answer any questions you might have. Thank you.
Great, thank you. Next up is Kat Brady from Community Alliance on Prisons. Good morning again.
Morning. Thank you so much for hearing this bill. As you know, the Hawaii Constitution has greater protections than the federal Constitution. And right now, we are in a time where rights are being challenged, ignored. So it's really important. One really important part of this bill is multifaceted discrimination. So it's not just one thing, your race or your sex or your gender. It's not that. It's people who have multiple areas of discrimination. A Black woman who is gay, that's 2. So, a disabled Native Hawaiian man, that's 2 or more. So we know that these happen. And I think this bill helps employers understand what multifaceted discrimination is. And they're better able to protect their workplace and their employees because of that. So I really hope that you pass this bill.
Okay,
Thank you.
Thank you. Next up is Aaron Cogan and Maggie Batangang for Sherm, Hawaii. In opposition, next to Sandy Ma for AAUW of Hawaii on Zoom, maybe.
Not present, Chair.
In support, Michael Galoyu Jr., Pride at Work Hawaii in support.
Good morning, Michael Goy Jr.
Oh, you are here. I'm sorry.
Yeah.
Go ahead.
He, him pronouns. Good morning. President of Pride at Work Hawaii. Happy St. Patrick's Day. We do want to thank you for hearing this bill. We stand in full support. One of the things that we would like to point out that hasn't already been brought to your attention is that this also takes care of our allies that are presumed to be part of the queer community just because they stand with us and they face discrimination. Currently, they without the Rice decision, they would have no recourse. And this gives clear guidance on that yes, just because you presume somebody to be a member of the community and you discriminate because of your presumptions, they should have protections under the law from and not face discrimination for that. So that this gives them a legal opportunity to address those regresses. So we encourage you to pass this bill. We thank you for hearing it, and I'm available for any questions. Mahalo.
Thank you very much. Next is Leland Brady for Aloha Independent Living Hawaii in support. Excuse me, Josh Frost for the ACLU or somebody else. Okay, thank you. Michael, there's a list of individuals after that that are all in support. Let me give you the stats. 16 in support, 2 opposed, and 1 comment. If there's anyone else who would like to testify on HB 1878, this is time to do it on Zoom or here. Seeing none, members' questions? Marcus Kawatachi for Civil Rights Commission, are you still here?
Yes, Chair, I'm present. Oh,
Can
let me
I
turn my video on. Yes.
Thanks. So my understanding is there's currently a federal Ninth Circuit case that that this bill basically tracks. Is that a fair characterization?
In terms of the intersectionality portion of the bill, it would track that decision. I think you're referring to the Lamb decision from the 90s.
Yeah.
That's the one.
Okay, so what proponents are concerned about then is if for some reason that decision was overturned, then there would be no, or if another case came up through and then it was a different result that time, there'd be no state protection.
I think to be cautious, it would make sense to codify the holding of that decision within our state law to make it perfectly clear. Whether or not the Civil Rights Commission would change its interpretation, I think remains to be seen if that ever were to occur. But I will say that the Lamb decision confirmed what we had been doing from the start anyway, that we did feel that intersectionality of claims was a valid way to look at, real life occurrences. So hopefully that answers your question.
Yep, it does. Thank you very much. Other questions, members? Okay, if not, we'll go ahead and move on to the next bill. This is HB 2089. This establishes a fixed disposition deadline requiring the Supreme Court to decide an application for certiorari within 60 days after the application is filed. First up on 2089 is Haley Chang from Public Defender.
And on her in support.
In support. Okay, next is Thomas Hughes, Deputy Solicitor General. Oh, you're here. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, members of the committee. My name is Tom Hughes, and I'm a Deputy Solicitor General in the Department of the Attorney General. The department supports this bill. The bill would ensure that every application for a writ of certiorari receives a full 60 days of consideration, regardless of whether or when a response is filed. Parties before the Supreme Court would benefit from the certainty this new deadline provides, and the public would benefit from the additional consideration given to applications that might otherwise have to be reviewed at a faster pace. The bill would also improve judicial efficiency, as the judiciary's own testimony makes clear. And it would clarify how the certiorari deadline interacts with weekends and state holidays, which is currently unclear. Finally, because this is a bill about the Supreme Court, I'll make an appeal to precedent. The committee passed the identical Senate companion bill in February, and so we urge you to do the same here. Thank you, and I'm available if you have any questions.
Great, thank you. Next is Nicholas Severson for the judiciary. On Zoom, maybe? Yep, there you are. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. Nick Severson, staff attorney for the Hawaii Supreme Court, testifying on behalf of the judiciary in support of HB 2089. We stand on our written testimony and believe that this bill promotes judicial efficiency and provides clarity for court staff and litigants alike. I'm available to answer any questions you may have, and we thank you for the opportunity to testify.
Thank you. Next up is Mark Murakami for the Hawaii State Bar Association.
Chair, HSBA staff.
In support, okay. That's everybody who signed up on HB 2089. Would anyone else like to testify on HB 2089? Okay, seeing none, members' questions? I don't have any either. Let's go ahead and move on to HB 2090, relating to domestic abuse orders for protection, removes the requirement the request to withhold from public inspection the petition record of a denied temporary restraining order or denied protective order be made orally. First up on 2090 is Judge Medeiros for the judiciary or designee. Good morning.
Chair Scott Boone on behalf of the judiciary. This is one of our package bills. We stand in support, obviously. And what this bill is attempting to do is iterate on Act 18, which was recently passed in 2020 to give domestic abuse survivors the opportunity to submit written requests to withhold certain documents from public view. And I'll be available for any questions you may have.
Great, thank you. Next up is Yasmin Cheney for the Hawaii State Commission on the Status of Women on Zoom. Good morning.
Good morning, Yasmin Cheney for the Commission on the Status of Women. I stand on our written testimony in support of this measure and thank the committee's consideration and support. Thank you.
Thank you very much. Next is Angelina Mercado for the Hawaii State Coalition Against Domestic Violence and support Mark Murakami for Hawaii State Bar Association.
Chair will stand on.
In support. Okay. Isabella Zingray, also in support. That's everybody who signed up on HB 2090. Would anyone else like to testify on HB 2090? Okay, seeing none. Members, questions?
Yes, I do.
Senator
Judiciary. Geez, I'm just trying to figure out the mechanics of this. So it's if the petitioner requests the removal of a counter TRO, which is what the judiciary's testimony was referring to. Does that mean for denied counter TRO, does that mean you folks will remove it from GEMS or Jeffs or whatever?
No, Senator, I believe it would be designated as sealed or confidential, basically withheld from public inspection at that point in time.
Okay, so it'll still be listed in GEMS like the defendant that files a counter TRO FCDA claim.
I would have to check. I'm not sure right now under current law if an oral request is made, if I understand the question, if that case file is then searchable or if it'll show any information when you search for it. But the particular petition itself would be designated as sealed or confidential.
Okay. So we will need to amend this if we wanted to remove it from GEMS.
I think if the legislature was going to look at that, I think it would need to be amended. I would have to look further into applicable.
Then hopefully before conference to remove those frivolous counter TROs from also GEMS, yeah.
Understood, Senator. I would have to look at potential applicable federal and state law where, you know, certain documents can be removed from public inspection, but there's
just want the actual.
But they're not just erased completely. There's still there within the system. So I would have to look into that to see whether or not there's any sort of federal or state law implications to have it removed completely.
Okay, I see the utility of this for the frivolous counter TROs that, you know, used to practice family law, and I've seen this. My concern is that it's still there, searchable under GEMS. So if I put in a victim's name and there is going to be an FCDA action, which is sealed by those, it's still there. Yeah.
That part I'm not sure on. I can definitely respond back to this committee with how that works technically, because I'm not sure if you search for that party's name, if it's going to return that sealed case. I'm not sure if it does or not. I do know that
I've seen it. Well, I haven't checked for a while, but I've seen it. Okay, and that's the reason I'm asking you the question. Okay, thank you.
Thank you, Senator.
You can stay there for a second. So my understanding is this bill just, because this bill, there's only a two-word change. It's oral or written twice.
Yeah.
So it's not really aimed at whatever the situation is now in terms of whether you can see the document. This won't change it at all. This is just how you make the motion.
Correct.
Okay.
Fair.
Just want to be sure I was understanding it correctly.
Yeah.
Okay.
And maybe I'm asking for too much, but okay, that may be for next session. Thank you,
Senator.
Other questions, members? If not, we'll go ahead and move on to HB 2094. This increases the amount each juror or prospective juror is paid for each day of actual attendance at court. First up on 2094 is Haley Chang for the public defender. Good morning again.
Good morning again. The Office of the Public Defender is in strong support of this measure. We know firsthand how critical it is to remove any barriers to jury service. And while it is a civic duty, it can put a great strain on individuals, especially for cases that last longer. It's a nominal change and we recognize that, but it can make a significant difference to getting a broad cross-section of our community to be able to show up in a meaningful way for jury service. So we stand in strong support and I'll be available for any questions.
Great, thank you. Next up is Dean Haraki for the judiciary. On Zoom, maybe. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. My name is Dean Hiraki. I'm the Deputy Chief Court Administrator in the Third Circuit, appearing today on behalf of the Hawaii State Judiciary. The judiciary strongly supports House Bill 2094, House Draft 1. This bill seeks to increase the jury compensation from $30 to $50 per day. We are seeking an appropriation of $684,385 to account for this increase. We know this increase is modest and will not replace any lost wages, and that the legislature has, many difficult decisions on a number of other funding requests this session. But we are still asking for this increase on behalf of the residents of Hawaii who serve this important and vital role in our justice system. Thank you for the opportunity to testify, and I will be available for any questions. Thank you.
Great, thank you very much. Next is Christine Denton for the Department of Prosecuting Attorney, City and County. In support, Mark Murakami, Hawaii State Bar Association. In support, thank you. Next is Johnny May Perry in support, Glenn Kagamita in support, Marcella Alohalani Boydo in support. That's everyone who signed up to testify in HB 2094. Would anyone else like to testify in HB 2094? Seeing none, members, questions? Okay, let's go and move on to the next bill. This is HB 2099. This amends the processes for addressing party candidates and state Senate vacancies. First up on 2099 is Scott Nago, Chief Election Officer.
Sure, we'll stand over contested support and be available for it.
Great, thank you. Next is Christine Andrews, also in support. And that's everybody who signed up on HB 2099. Would anyone else like to testify on HB 2099? I'm sorry, yes, 2099. If not, members, questions? Okay, we'll go ahead and move on to the last bill on the agenda, HB 2578. This provides a determination of personal liability for another person's unpaid general excise taxes as an assessment subject to the due process procedures and appeals available for other assessments. First up on 2578 is Department of Taxation. Theoretically in person, but with comments. And that's everybody who signed up on HB 2578. Does anyone else wish to testify on HB 2578? Seeing none, members, there's no one to ask questions of. I'm ready to start voting if you guys are. Any issues? Okay. Let's go back to the top of the agenda, HB 1247. And this allows a party aggrieved by the judgment of a circuit court on a minimum term order to appeal to the intermediate appellate court, requires prisoners to continue to be represented by counsel in the petition challenging minimum term proceedings. I think this is a work in progress. I'm inclined to move it forward. We have a couple of amendments that will hopefully make it better. So I'd like to accept the public defender's amendment and apply to the right to counsel provision to all prisoners, not just those who have been previously represented. But both the public defender and the judiciary requested additional money to move forward with this. So we'll go ahead and put in 2 blanket appropriations for those 2 agencies, and I will put a different bad date on it, March 22, 2075. Questions or concerns? If not, Senator Gabbard.
On HB 1247, the chair's recommendation is to pass with amendments. With all members present, are there any no votes or reservations?
No.
No votes for Senator Wah. The measure passes.
Thank you. Next up is HB 1516. This requires certain factors to be considered when determining a defendant's financial ability to afford bail. Recommendation here is to basically conform the amendments with what JDC did on Senate Bill 2732. So what that entails is clarifying the reference to the 150% of the federal poverty level for Hawaii by specifying the use of the annual published federal poverty guidelines and setting the time for determination as the date of first appearance. The first appearance is different than what's in the bill now. It's arrest. And then we'll adjust within 40 hours of arrest to within 40 hours of initial appearance. And we'll put a different bad date on it, 3/22/75. Questions or concerns? If not, Senator Gabbard.
On HB 1516, recommendations to pass with amendments. Any no votes or reservations?
No.
No vote for Senator Wah. The measure is adopted.
Thank you. Next up is HB 1565. This establishes a working group within the judiciary to improve family court proceedings, including access to legal representation for youth in the child welfare system. Appropriates funds for the working group. The recommendation here is to pass with amendments. We'll put a different bad date on it, March 22, 2075. And in the committee report language, you'll note the judiciary's budget request of $140,000 and the breakdown that they gave in their testimony. Questions or concerns? If not, Senator Gabbard.
Chair's recommendation on HB 1565 is to pass with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you. Next up is HB 1716. This establishes a process by which any political party continuously listed on the general election ballot for 8 or more years shall be deemed continuously qualified for ballot placement. As I mentioned when we were speaking with the testifiers, I'm a little concerned about treating different parties differently. So my recommendation is to pass with an amendment that treats all the parties the same, but it will make it easier for all political parties to qualify for the 10-year status by lowering the number of cycles where you qualify from 3 to 2, and that's in HRS 11-62B. And we'll put a bad effective date on it of March 22, 2075. So it boils down to a pretty small. It will look like a big change in the bill, but it's in the same spirit in which the bill was offered, I believe. Questions or concerns? If not, Vice Chair.
On HB 1716, recommendations to pass with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Okay, thank you. Next up is HB 1878. This prohibits discrimination based on the perception that a person possesses certain characteristics, the perception that a person is associated with a person who possesses or is perceived to possess certain characteristics, or the intersection or combination of 2 or more specified characteristics in relation to a person. The recommendation here, as was mentioned in the testimony, the current common law in the, I believe it's the Lamb case, already this is basically the law in Hawaii now, but this would take that decision and put it into state law. So recommendation is to go ahead and put a good date on it and move it forward. So it would be upon approval. Questions or concerns? If not, Vice Chair.
On HB 1878, recommendations to pass with amendments. Any no votes or reservations? Hearing none, the measure passes.
Okay, next up, thank you. Next up is HB 2089. This establishes a fixed disposition deadline requiring the Supreme Court to decide an application for certiorari within 60 days after the application is filed. I'm surprised this wasn't requested like 15 years ago, but recommendations to pass as is, so it will go. This is it, so it'll go straight up to the president or up to the governor after it clears the floor. Questions or concerns? If not, unamended.
Recommendation on HB 2089 is to pass as is. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you. Next up is HB 2090, removes the requirement that requests to withhold from public inspection the petition record of a denied temporary restraining order or denied protective order be made orally. Taking note of Senator San Buenaventura's concerns, I don't think this is that bill. I understand where you're coming from, but it's my recommendation is to just pass it as is. Questions or concerns? If not, Vice Chair.
On HB 2090, recommendations to pass as is. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you. Next up is HB 2094. This increases the amount each juror or prospective juror is paid for each day of actual attendance at court. Recommendation is to put a different bad date on it, March 22, 2075. And note in the committee report that the appropriation amount is blanked out in the bill, but the appropriation amount requested by the judiciary in the original bill was $684,385. Questions or concerns? If not, Vice Chair.
On HB 2094, recommendations to pass with amendments. Any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 2099. This amends the process for party candidate and state Senate vacancies. It's mainly to comply with federal law about the length of time you have to have certain things done before the election. Recommendation is to pass it as is. Questions or concerns? If not, Senator Gabbard.
On HB 2099, recommendations to pass unamended. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you. Next up and last is HB 2578. This provides that a determination of personal liability for another person's unpaid general excise taxes is an assessment subject to the due process procedures and appeals available for other assessments. The recommendation here is to just I'll go ahead and we'll go ahead and put the effective date that I think it was judiciary asked for. DOTAX, I'm sorry. DOTAX asked for, which is January 1, 2027, and there is another committee after this. Questions or concerns? Not, Vice Chair.
Recommendation on HB 2578 is to pass with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Great. Thanks everyone for being here. We're adjourned.